So those real estate attorneys talk so much downstairs. I'm sorry, Floyd, they just talk, they're working deals. They're working deals. I'm really sorry. Okay, we're going to get started. This is really a thrill for us to have a man of the stature of Floyd Abrams come here. And it's a thrill because not only the nature of him, but how this all happened. I'm always curious as to how this sort of works its way through to having an appearance of a man of this stature. And it really came through Nick Norton. I want to introduce Nick Norton, who is front row and center. And Nick is the town of Arkwright supervisor. And in the wild world of serendipity, which happens at the Jackson Center more often than we care to admit, Nick, a few years ago, called me and said, Greg, I want to be introduced to you because I have an idea concerning wind tower project in the town of Arkwright. You're the County of Chautauqua Industrial Development Agency attorney. I'd love to talk to you. So we went to Moonbrook, and we talked about that. And at the same time, he was then patting me on the head saying, what you've done at the Jackson Center is fantastic. Congratulations. And oh, by the way, in my prior life, outside of being the town of Arkwright supervisor, I went to Yale Law School. And one of my colleagues at Yale Law School was a guy named Floyd Abrams. Have you ever heard of him? And of course, the answer is absolutely. So it stuck in the back of my mind like Velcro was this relationship that Nick Norton had with one Floyd Abrams. We can talk about that later, Floyd, if you can disavow him if you like. So what happens is this past spring, Floyd authored a book called The Soul of the First Amendment. And The Soul of the First Amendment is, in fact, available. We got a limited copies, and Floyd signed them. If you're interested, they're $25. But it was critiqued in the Wall Street Journal, and I'm sure elsewhere, incredibly well. And there was quotes within the book which had Robert H. Jackson in it. So my friends at various law firms sent that to me. So then I reached out to Nick. I said, you remember 6 years ago, you mentioned the fact you dropped a big name, Floyd Abrams. If I work with you, could you possibly reach out to Floyd Abrams? And sure enough, he did. Next thing you know, Mr. Abrams was kind enough to call me or email me on a Sunday saying, hey, I'm interested in Jackson, got this note from Nick Norton, when can we do it? So here's the day. So it's fantastic, and so kudos to Nick Norton, if we could give him an applause. And before I turn it over to Professor Samantha Barbas to really formally introduce our guest speaker, I want to acknowledge the fact that today is our first Joseph Gerasi lecture. And Judge Gerasi, who was here on his 90th birthday, a fund was created by family, friends, and the members of the Jamestown Bar Association to have annually a distinguished lecturer here, and nobody more distinguished than Floyd Abrams. So glad you're here, Judge Gerasi. Let's acknowledge him as well. Thank you. This is being filmed. You don't have a problem with that, do you, Professor? Good. I didn't ask. And so with that, I will turn it over to her to do a formal introduction, and then Mr. Abrams and I will have a conversation.
Hi. It's my great pleasure to introduce Floyd Abrams, who has been for over 4 decades one of our nation's greatest advocates of the First Amendment. A lawyer representing major media organizations since the 1970s, often before the Supreme Court, Mr. Abrams has fought zealously for the rights of the press, winning important victories for the media in precedent-setting cases. Mr. Abrams has been described rightly as the most significant First Amendment lawyer of our age, whose name is synonymous with the First Amendment in a way that virtually no other name is. Mr. Abrams earned his law degree from Yale in 1960. He did a federal court clerkship and began practicing at the firm of Cahill, Gordon, and Reindel in New York, where he's still a partner. And at the time he began practicing law in the 60s, when he was being called on to represent media clients, there was relatively little media law. There were at that time only a handful of Supreme Court cases on the First Amendment rights of the press. Just a few years earlier, in 1964, the court had announced its historic decision in New York Times versus Sullivan, creating constitutional protections for the press in libel law. Aside from Sullivan, however, the rights of the press under the First Amendment was largely uncharted terrain, and there were many open questions. For example, should journalists be able to keep their sources confidential, and under what circumstances? Should the press have a right to publish true facts, even if those facts might invade someone's privacy? Should the press be limited in any way in its criticism of public officials? Should the government be able to quash the publication of information in the name of national security? Mr. Abrams rose to prominence in 1971 as co-counsel for the New York Times in the famous Pentagon Papers case involving the publication of top-secret documents. The Pentagon Papers was a secret history of U.S. involvement in the Vietnam War from the Truman administration through the Johnson administration, and the Times began publishing it in mid-1971. The conflict in Vietnam, of course, was still going on at that time. The Nixon administration sought to enjoin the Times from printing the material on the grounds of national security. And at the district court, the government was able to bar the paper from printing the stories. The Times suspended the publication of the Pentagon Papers while appealing the injunction to the Supreme Court, and it was the first time in American history that the government had exercised a prior restraint on the press. The Times ultimately prevailed. The Supreme Court decided by a 6-3 vote that there was not sufficient justification for a prior restraint, and the landmark case launched Mr. Abrams' career as a First Amendment lawyer. Since then, he has handled several of the most important First Amendment cases of the last 4 decades, dealing with issues such as prior restraints, libel, privacy, the censorship of art, confidentiality of reporters' sources, campaign finance. He's represented virtually every major media organization: CNN, ABC, NBC, CBS, Time, The Nation, among many others. He's argued more First Amendment and media cases before the Supreme Court than any lawyer in United States history. Mr. Abrams has taught law and journalism at schools like Yale and Columbia. He's a distinguished scholar of the First Amendment and the author of several books, most recently The Soul of the First Amendment, which was published this year. It's a wonderful book, slim and eloquent. It describes the past, present, and future of the First Amendment, and I'd encourage you all to read it. The book takes on such contested issues as campaign finance and the Citizens United case, which Mr. Abrams was involved with. It looks at Europe's right to be forgotten online, right? The right to have truthful information deleted from the internet on demand. And whether there could ever be something like that in the United States, thankfully no. The book also discusses the perennial difficult question of the regulation of hate speech, and it looks at the history of the First Amendment as well. The book reminds us how new freedom of speech and press really are. Right? A century ago, censorship laws restrained expression in ways that we would find unimaginable today. Mr. Abrams, in his book, explains the uniqueness of the First Amendment, what makes America's protections for the press so special, why we have more robust protections for free expression here than anywhere else in the world. He describes what he calls the spirit of the First Amendment. In his words, the First Amendment's anti-censorial soul. As he writes, the essence of our approach to freedom of speech is the belief that the dangers of permitting the government to decide what may and may not be said outweigh any benefits that may result from suppressing offensive speech. And so the question I have for Mr. Abrams, and that I'm sure he'll explore today, is how the soul of the First Amendment is faring in today's very conflicted and turbulent times. What is the future of the First Amendment at a time when, according to the polls, distrust of the press is at an all-time high? What is the future of the First Amendment in our age of social media and unrestrained online communications? in a time when more Americans than ever, especially young Americans, seem to be saying that they would like to see more restrictions on controversial expression. Where do we go from here? Thank you.
Thank you, Professor Barbas. And by the way, she's a professor at the University of Buffalo Law School, and teaches First Amendment law and mass communications law. She holds a PhD in American history from the University of California at Berkeley, which has had its own interesting First Amendment questions here recently, and a JD from Stanford Law School. So I'm so thrilled that she not only did the introduction, but critiqued the book. And most importantly, to set the stage, you grew up in the New York City area, and I just want to know, was it Willie, Mickey, or the Duke that grabbed your attention?
Well, why don't we put it this way? My cell phone has a number 7 in it. So those of you that know the numbers of the players can figure it out. But I was a Mickey, and I'm old enough, I must say, to remember Joe DiMaggio, too. So I was born in the Bronx, brought up quite religiously as a Yankee fan.
So what were you doing last night?
I was watching and worrying.
Well, the ninth inning got very interesting.
Yeah.
So thank you. Can you give me your best story about Nick Norton? Because he was going to give me a couple on you.
Well, he hasn't given you one, so I don't think I will.
Well,
Maybe we can work something out of silence. But I remember him very well from law school. You know, it's interesting when you graduated from someplace some years ago, and you knew people, some people really well, to re-meet them at a time when they're a few years older, and you are too, from when you met. And so all I'll say about Nick is that he's just the same person that I remember from law school all those years ago.
Nick did provide me a little bit of biographical background on your wife, that Efrat,
Right.
and that she fought as a guerrilla in Israel versus the British. And was it
That's a little exaggeration, and she isn't quite that old. That would put her at an older generation, but she was a sergeant in the Israeli Air Force and was serving in that capacity during the 1956 war.
and biographically, also, your son is a legal correspondent.
Yes, Dan Abrams, some of you may know, I hope, from ABC News, and where he is frequently on Good Morning America, and on the evening news when legal issues arise, and has his own show. It's wonderful advertising here today on A&E called PD Live, which is a very popular new program where they follow police cars around the country with cameras in the cars live.
And your daughter is a federal district court judge.
Yes, my daughter Ronnie was appointed by President Obama 4 or 5 years ago now to the Southern District of New York and sits as a federal judge.
Do you get occasional calls from your children saying, "Hey, Dad, I got this issue"?
I do. It's, I sometimes wonder if they had any choice about becoming a lawyer or not. I really didn't do it on purpose. Only years later did it occur to me that a father who, instead of telling fairy tales, would talk about cases might have some impact on their children.
Do you bring it home? Do you come home? Does your wife listen to, as you muse about these issues?
Not too much. I did bring home one, and a case in which I was representing Random House, a book that contained a book that contained information which was classified and provided by a former State Department official and a former CIA person. This was before the Supreme Court had decided cases in that area. And the author had signed an agreement within the CIA saying he would not reveal anything he learned which was classified. And I was representing basically him as the author of the book. And we had some pretty good arguments that the material wasn't really classified, and that in any event didn't meet whatever test we were arguing the court had. In any event, I told my wife, and she said, well, he signed it, didn't he? I said, well, yeah, he signed it, but, well, that's what the court said. So the lesson is sometimes a non-lawyer can make an immediate and quite correct judgment as to where the courts are likely to go.
You sit here today and you listen to the introduction by Professor Barbas, and recently I was just watching my source of all knowledge, which of course is YouTube, and they were introducing the fact, there was a question regarding the First Amendment. I said, well, who's the most prominent First Amendment lawyer in the country? And they said, Floyd Abrams. And then that follow-up question was, who's number two? Dead silence. And as this is a tag that they've given to you, whether you wanted it or not, but it is a fact, is that a heavy load? Is that as being sort of the go-to guy on the First Amendment?
Oh, look, it's nice. What can I say? This is, it's nice to be well thought of. And obviously, there are a number of lawyers who do terrific First Amendment work and a number of scholars who make great contributions in the area. But, it doesn't pain me to have people say such things.
First Amendment, obviously, part of the Bill of Rights, but as far as the United States Supreme Court actually discussing it, is a relatively new phenomenon. Why do you think that is so?
Well, just to expand it a little bit, it's almost startling to think of the fact that, here the Bill of Rights was adopted in 1789. There were no First Amendment cases in the whole 19th century. There's none in the Supreme Court. And really not till World War I, 100 years ago this year, did there really start to be what were viewed as First Amendment cases. There was a lot of what we would understand now to be violations of the First Amendment. Routine censorship on the stage, on movies as they were then, of newspapers. I mentioned in my book, I wrote an introduction to a book I found really fascinating called Political Censorship. It was just all the columns in the New York Times, maybe not all, but the New York Times writings about censorship around the world for the entire 20th century. So it was 1900 to 1999. And you start reading about the early part of the century, and, in Idaho, an editor goes to jail because in violation of an Idaho law, they described a hanging, because there was a statute that made it a crime to describe a hanging. And in Illinois and in other states and in Pennsylvania, one situation after another, movies subject to the strictest censorship. And all that was routinely going on, laconically reported on by the New York Times in those days. And it was really, again, not till World War I and the prosecution of socialists and anarchists who were against the U.S. being in the war and who were giving speeches, including the candidate for the presidency of the United States, Eugene Debs. Debs was jailed for a few years basically for his advocacy of opposition to the war. And that led to, eventually, the very famous dissenting opinions of Justice Holmes and Justice Brandeis in the Supreme Court, which is really the beginning of what we would now call First Amendment law. Those dissents became First Amendment law in one way or another. But that was already the 1920s, and not till the second half of the 20th century, with two New York Times cases, New York Times against Sullivan, which has been mentioned, which was a case involving the New York Times being subjected to one libel suit after another in the South as it reported on the Civil Rights Revolution of the 1950s and early 60s, and Time Magazine and CBS, all losing one case after another in front of all white juries who were infuriated by the coverage of the Civil Rights Movement. Not till 1964, therefore, did the Supreme Court have such a case, and it ruled very broadly in favor of the Times, but more important, it established new law designed to protect the press, as the court thought it was entitled to protection, because the public was entitled to the information and the news and the opinions of the people who were writing this. That was all 1964. And then 7 years later, the Pentagon Papers, which I was involved in, came before the court, extraordinary decision if viewed on a worldwide basis. Highly classified information during a war, at a time when there were Americans being held as prisoners of war by the Vietnamese. But the American Secretary of Defense, Mr. McNamara, had decided well into the war that it would be a good idea to find out how we got involved in the war. And so he commissioned a study by the Defense Department of how we got into the war in Vietnam. The study was 23 volumes, 7,000 pages, which 3,000 were New York Times articles, basically, but 4,000 pages of highly classified information. Highly classified doesn't, in reality, necessarily mean important or dangerous, but highly classified. And it was leaked. It was, at its time, the largest leak of information in American history. Now we live in a world in which millions of documents are leaked simultaneously because of the nature of our communications processes and the technological age in which we live. But the Times, in any event, published articles, almost all purely historical in nature, of how the U.S. became involved in the war. Nothing about military plans or the like. And the government went to court, and we won. The court said, as has just been said, that there was insufficient evidence by the government to show that a restraining order, an injunction, was consistent with the First Amendment. My wife and I happened to go on a long-planned visit right after that case. The case took 15 days, by the way, extraordinarily, stunningly quickly, from the day it was filed to the day the Supreme Court decided it. 15 days. And we went by plan to England and to Switzerland and to Israel. And the journalists we met in all the countries were stunned by the result. The government, in the middle of a war, with respect to classified information says that irreparable harm will befall the public if this is published and you're allowed to do it? And they all said, unthinkable. And, you know, because we have a First Amendment and because we had judges who were willing to say, in effect, while we take into account, as we must, the greater experience and knowledge and know-how about diplomatic and military matters by the executive branch, when the government wants to try to stop a newspaper from publishing news, it has to show that it has a very serious basis for doing so, and that they had failed to do so. Well, that was just one example of how different we were and are from the rest of the world in terms of legal protection. But back to, I would say, those two cases, both involving the New York Times, I mean, that was really the beginning of a series of cases taking very expansive views, and this has been true when the court was dominantly liberal, and now when it is dominantly conservative. It has been true from New York Times against Sullivan, say, in the 1960s through today. That is, you know, sort of how we got to where we are in this area, where we are unique in the world, and I would argue maybe even unique in American history, in the degree to which there is a very high level of protection for free speech.
You mentioned in your book, The Soul of the First Amendment, reference to Daniel Ellsberg, who was, in fact, was the source of the leak in the 1971 case, where he wrote a book it's entitled Secrets, about leaking of the Pentagon Papers, and he says, of course, there were circumstances such as diplomatic negotiations, certain intelligence sources and methods, or various time-sensitive military operational secrets that warranted strict secrecy. And he, in fact, did not reveal 3 volumes which dealt with the negotiations, as he felt that may interfere with the process. So he sort of self-imposed a little bit of constraint himself.
Sure. Well, I mean, Dan Ellsberg has views which are generally, I guess, considered radical views on a lot of subjects. But, I mean, he was a Marine. He takes very seriously, in his way, by his own lights, the notion that there are some things that cross the line and should not be leaked. He declined to testify for Private Manning and the Manning case because he thought that material had been released by Manning, which should not have been. I mean, he takes a very permissive view of where to draw the line, and certainly not a view consistent with where the CIA would draw it. But he does draw a line, and he does not approve of going beyond it.
You don't wake up one morning and become a First Amendment lawyer. How did that all happen within the structure of your firm?
Let me say first that I was sort of on the other side when I was in college. My senior thesis in college was about some of these topics, but it was what was then called trial by newspaper. Back in the 50s, there was a lot of discussion about whether the press ought to be allowed to publish information which was inadmissible at trials, which is the English way. In England, you would go to, an editor would go to jail for publishing a confession or a prior criminal record. To this day, that would be a contempt of court in England, and it was that way in the 1950s when I was in college. I found that very attractive at the time. I thought, I mean, if it's the sort of thing which a jury shouldn't hear, why does the world have to hear it? I did come to change my mind in the 1960s during the Nixon administration, where it seemed that the government was prepared to take stronger and stronger steps to limit the press or limit the First Amendment in one way or another. And in the late 1960s, the Democratic Convention in Chicago, which was a wild affair with policemen beating up journalists and radicals trying to disrupt the Democratic Convention, was followed by a series of criminal prosecutions in which the government subpoenaed journalists again and again and again to testify, mainly because journalists were viewed, then at least, as responsible members of our society who juries would trust. So these public events would happen. Dr. Spock was indicted for some things he had said against the war in Vietnam or encouraging people not to go and register. They called journalists to testify. And the broadcasters and the newspapers were becoming very upset, at least as much on the grounds of interfering with their time all the time. Journalists were being called. And then more and more it became confidential sources of journalists which were being sought, which strikes much more deeply at the core of the ability of the press to do its job, all in the late 60s. And because my law firm had represented NBC for a number of years before I got there, NBC was one of the entities that both had confidential sources that its news people had, and the interference with its journalistic process by people having to show up all the time to testify. And so the press started to sort of coalesce around certain notions that there had to be a level of First Amendment protection, at least that the press ought to go last if there are other witnesses, or at least that confidential sources shouldn't have to be revealed if there was some other way to get the information, or if it wasn't really needed. And we started to make arguments like that in court. And it was during one of those cases, which ultimately was in the Supreme Court, that the Pentagon Papers case came into being. And at the very same time, we were working on a brief about confidential sources of journalists. The Pentagon Papers case fell into my lap and made me, quote, a First Amendment lawyer, unquote.
So, on various occasions, you've had an opportunity to go to the United States Supreme Court.
Yeah.
So tell us about your first experience when you get up to the podium and say, "May it please the court."
My first experience was a case called Nebraska Press Association versus Stewart in 1976, which was a case involving a criminal prosecution in a state court in Nebraska. Any of you that have seen the movie about Truman Capote, that was that case in savage murder of a family in a rural community in Nebraska. The defendants arrested very quickly afterwards. And the judge, almost by rote, entering a prior restraint against anything being published, which was almost the English system, anything being published which was not admitted in court. So that the Nebraska press objected to that, and it finally went to the U.S. Supreme Court, and a wonderful lawyer named Barrett Prettyman from Washington represented the Nebraska Press Association. I represented the press in general of the country. And what was it like? It was nerve-wracking on really two levels. The case really mattered, and the result in our favor has had a very great effect and, in my view, a very freedom-sustaining effect by basically ending the time when, certainly when judges routinely, but even more than that, when judges almost ever enter restraints about what a journalist can print about ongoing trials in America. So from an ideological point of view, from the point of view of the ability of the press to do its job, and I thought from the point of view of the public's right to get information, it was sort of a heavy weight. And then on a personal level, you know, one gets up in front of the Supreme Court, especially for the first time, you don't want to fail. You don't want to look bad. You don't want to not know an answer to a question. You don't want, for example, as I did years later when Justice O'Connor had just been appointed to the court, the first woman ever on the court, to say to her, "Sir," because I couldn't quite decide what words one is supposed to use. Would have been easy to call her Justice O'Connor. So yeah, there's always a risk, I think it's fair to say, of personal humiliation. The justices are smart. Their law clerks are smart. They come in with tough questions. And you really have to be prepared. And in that case, really in all my Supreme Court cases, I go to Washington days in advance, check into a hotel, and that's what I'm doing, is answering questions, thinking of questions, talking to people. A lot of lawyers do a lot of moot courts, preparations with people literally playing the role of judges. I don't do that very much. I don't like those very much. But whether one does that or simply sits, as I tend to, and go over a question and go over an answer and try it again and see if it works and see what the follow-up question is likely to be. I mean, remember, you should know the case as a lawyer better than any judge. It's your case. I mean, you've been with it. You wrote the briefs. You should be the expert on it, certainly about anything factual, certainly, but even beyond that, you ought to be better able than the judge to think of all the questions a judge might ask, because that's your life. They have other cases. By the time you're in the Supreme Court, this is the only thing on your mind, it takes a lot of focus and sort of full-time psychic energy to try to be clear as to just what it is you're saying and not saying, and just what the distinctions are you would make, and just what the concessions are that you would make. And a lawyer who does it well has done that well prior to standing up in the court.
Well, you dropped a name there as your co-counsel of E. Barrett Prettyman
Yes.
Jr. And E. Barrett Prettyman Jr., for some of you, was Robert H. Jackson's last law clerk. And probably a moment in time, I'd be remiss if I didn't mention not only E. Barrett Prettyman Jr., who sat at the same seat you sat many times, but does Robert Jackson fit into your jurisprudential thinking, First Amendment?
Oh, a lot. I mean, I've written 3 books, and one of them, it was a quote from Justice Jackson, which is emblazoned towards the beginning of the book. It's Justice Jackson was a superb writer and could express, I don't want to just say as well as any, in the First Amendment area, could express better, I think, than any other jurist, the heart, the core of the First Amendment. I've been thinking, for example, about the following. Next month, I'm going out to Kansas to talk to 1,400 high school students about the First Amendment. I asked myself, well, what am I going to say? How do you communicate with them about this otherwise very abstract notion? And it's the Barnett case. It's the case of the young girl who was expelled from school because she wouldn't salute the American flag, because she is, during World War II, by the way, because she was a Jehovah's Witness, and they believed that would be inconsistent with their religious beliefs. And Justice Jackson, who wrote that great opinion, maybe the greatest First Amendment, religious freedom and First Amendment freedom generally, maybe the best ever, of saying that the school couldn't expel her for that reason. He is much in my mind. He's also so easy to use in a brief, in a document you're writing for the court, because his skill at capturing the essence of the First Amendment as what I did call an anti-censorial barrier against the government transcended, I would say, any other justice.
That quote, the Barnett case, the constitutional constellation quote, which does get a lot of play, especially now, especially because our current president tweeted regarding the NFL players and kneeling, and then that became a time of an object lesson for students. In fact, we just had our superintendent of our schools talk exactly about that subject and how Jackson plays into that.
Well, the Attorney General Sessions, just quoted that whole passage from Barnett in a speech he gave denouncing the players, but nonetheless, but he quoted it all, and I was asked by some journalist to comment on it, and I said, I just wish he would read that to the president.
So as your career path goes on away here, and all of a sudden you get the Nebraska case, and then now are you getting calls from these various news organizations? Is that who you tended to act as your client base?
Yeah, I get a lot of calls for comments. President Trump provides a treasure of opportunities to comment on First Amendment issues, yeah, I have gotten a lot of calls from the press about it, and just yesterday about the NFL situation, I had a call asking if the owner of the Cowboys could fire players. Would that violate the First Amendment? And of course, the general answer is no. The First Amendment just applies to the government. The Bill of Rights just applies to the government. There may be employer-employee issues, union issues, public policy issues, of course, but the First Amendment is and only is, and was meant to be only, a limitation on the government. You know, when Madison first drafted, it was couched otherwise. It was couched as the people shall have such and such rights. And by the time it cleared the Congress as what became the First Amendment, it was Congress shall make no law abridging the freedom of speech or of the press. And it's a big difference, and I think a valuable difference. I mean, one of the things I think it's important to bear in mind is that unlike the Declaration of Independence, which is an explanation to the world of why this new country was being formed and principles which underlay its formulation, including freedom-related, of course, principles. The Constitution, for the most part, is a blueprint of how this government would work, that there would be a president. The president would serve for 4 years, that there would be a Congress, that there would be the judiciary, and what each of them would do, and how old you had to be president. I mean, all those things are in the Constitution. But the Constitution and the Bill of Rights is a legal document. I mean, this is not rhetoric. This is not poetry. This is a legal, binding document. And because it is, the First Amendment, has come to have enormous impact in protecting the people from governmental suppression of speech, of the press, governmental involvement in religion, governmental limitations on free assembly and the like. And one doesn't have to argue anymore, and one doesn't have to argue at all about the proposition that in effect, because it's written down, I mean, this is not general common law, as we call it, from the English. This is an answer to the English as they were at the time of the Revolution and at the time of the drafting of the Constitution. And it was deliberately written to make very clear the range of things that the government could not do.
I feel like I'm in a con law class. This is terrific. We find our government, our laws really based on English common law. It was our structure. And at some point, the interpretation of the Supreme Court regarding our First Amendment differs pretty dramatically, steps away from what the English, how they interpreted that. Could you explain
that
a
was
little bit?
1941, and a great case, great in every way, and I would say one of the 5 most important First Amendment cases in our history, called Bridges versus California, in which a California newspaper was accused of contempt of court for writing an editorial saying that a judge who had a case in front of him involving a labor union which had violated an injunction, that a judge should sentence the head of the union to a long jail term, send him to the jute mill, was one of the languages in the Los Angeles Times. Under English law, that's a contempt of court today, as well as in 1941, saying to a judge what the judge ought to do, pressuring, you could say, a judge into doing it. And there was language from an earlier opinion of Justice Holmes back many years before, when Holmes was a young judge, supporting that proposition. And the U.S. Supreme Court, by a 5-4 vote, in a decision written by Justice Black, said that nothing was clearer, but that the American Revolution was meant to move away from, to reject English law, and to provide much more protection for freedom of speech, press, and religion than had ever been the case in England. Now, historians argue about whether that's accurate or not in terms of the intentions of the framers, but that's what the court said, And with that, we entered into a new regime of First Amendment law where it's really not helpful for a lawyer now to cite an English case. And English cases used to be the basis of American law. And so Justice Black held for the court that no, it was not it could not be a contempt of court simply to write an editorial ragging some judge or saying this judge was wrong or saying the judge ought to sentence someone to jail for a long period of time. Only, Justice Black wrote, where the publication is a clear and present danger to the administration of justice and an immediate one. Could there be a finding of contempt? And that notion of the divide, the deliberate abandonment of English law in that area came to be the beginning of a total rejection of English limitations on the press, which had existed and do exist to this day. I mean, Justice Potter Stewart, in a famous speech at the Yale Law School, said that the First Amendment is not an Official Secrets Act or a Freedom of Information Act. Not either one of those. It is a limitation on what the government can do and the limitations that the government may impose on the press. It doesn't require all information, government information, to be made public. It doesn't allow journalists to be put in jail just because they revealed secrets. There are certain circumstances in which they can. But that all began really from a juridical point of view in that 1941 opinion, which happened to be about the issue of contempt of court.
That continues to find uniqueness in the world of libel and defamation in suits that are brought in England as opposed to suits being brought here regarding presumptions.
That's why Hollywood people go to England to bring lawsuits. I mean, now that's, England has moved away from that. I mean, in the last 4 years, they've had certain reforms of their own internal law, which is meant to discourage people with very little connection with England from going there. But I mean, it has to have a greater, a substantial connection. But I mean, I've done cases for NBC, for example, where the Prime Minister of Jamaica sued for an American broadcast in Canada, brings a lawsuit in Canada where they have something closer to English law, saying his reputation had been hurt by something that NBC broadcast. Well, how's NBC in Canada? Well, because the signals go into Canada. They don't get advertising from Canada, but and he said, I've lost reputation in Canada. We argued in favor in front of the Canadian court that either he ought to apply American law, which was laughable in terms of our chances of success, or that he ought to dismiss it, as I think it now would be dismissed in England because of this new law. They ought to dismiss it, just basically saying, come on, this is an American lawsuit. The reputation that's been lost is in America. Everything that's happened here is peripheral. But the ruling was against us. The case, incidentally, was dropped after the first deposition. What the story had done was to link the Prime Minister to drug running. Basically said he'd taken money from people involved in that criminal industry. And after one day of depositions, they dropped the case. Depositions in Canada by Canadian counsel. But I mean, that's just a good example of how different legal systems are. I mean, even in friendly old Canada.
In your book, it's really based on 6 chapters, and one of the chapters you talk about is a discussion of the Europeans' legally enforceable right to be forgotten.
Yeah.
How does that work?
That's one of the most interesting recent developments in law in Europe, where the law now, in the name of privacy, is that if someone objects to a Google or a Facebook or the like, carrying old information, it's not clear how many years, but many years ago, 10 years I'd say anyway, 15 years, 20 years, information which is no longer relevant, that the person can object and it could no longer be carried online. I mean, the newspaper that published it could still leave it in its files, one could still get it if there are technological ways, as there are, of doing so from the newspaper. But these new entities, the Googles, couldn't carry it anymore. And over 500,000 newspaper articles no longer appear or are available or are carried, as it were, by Google because of this approach. Now, it has not been used with respect to politicians, certainly not politicians in power, and it is much more often private people involved in events that became newsworthy. So in Belgium, just a few years ago, for example, somebody wrote to Google saying, 15, 20 years ago, I drove a car and 2 people in the car were killed because of my driving. I was convicted of a crime of that. All these years have passed. I haven't done anything else wrong, and I'm just extrapolating a little bit to make it stronger. And my Google listing is just that. I'm a private person, and the only reference to me is about the automobile accident or transgression of 20 years ago. And Google shouldn't be allowed to carry it. Google argued that it should be, and the European courts said that that Google could not carry it. Now that would be unthinkable here. We would say here, it was truthful when it was said, it's still truthful. The government can't get involved in suppressing truthful speech, period. Indeed, I think our courts would also say there's no justification for treating Google differently from the files of whatever newspaper published it. But it is, a very interesting and important and quite new development. I mean, we're talking about the last 10 years, and in particular, the last 5 years. And one of the most pressing issues there, and it's almost always literally about Google itself, is can a French court require Google to drop it in America? Can a French court say and have binding effect on Google that you can't carry it in the U.S.? Not that anybody is on the European side is going to go to court in America. They're going to say Google in Europe would be violating a European court order unless it worldwide ceased carrying the information. And that issue is now being decided in the European courts. And it's a very important legal issue yet to be decided.
Somebody comes to your door and they got an idea, and they feel like they've been harmed. How do you choose cases that you, Floyd Abrams, will lend your name and the firm's name to? What's the vetting process?
I don't represent people who sue the press. No, I don't. Including non-clients or the like. I mean, I believe in libel law, so it's not that I don't think the press ought to lose sometimes. I just don't think I ought to be the instrumentality that helps to bring it about. I've been too close, too cozy, taken too much money, been too affiliated, and also don't want the news story to be that I, with, whatever notoriety I have in this area, I'm suing such and such a publication. So I don't have a problem in most situations. My firm doesn't do much in the way of plaintiff's work anyway. So, people, so what I do is I send them to a friend who does plaintiff's work. I never hear again. I mean, most cases either get settled or not brought or dismissed. There aren't a whole lot of trials in this area. There are some, as we saw in the Hulk Hogan case, for example, but that's still sort of on the unusual side.
This Wall Street Journal article, which I referred to earlier concerning your book, talks about that you have undergone an intellectual and political evolution. Your legal defense of the New York Times over its decision to publish the Pentagon Papers in 1971 made you a hero of the left. 4 decades later, you earned the enmity from former comrades by appearing before the United States Supreme Court in 2010's Citizen United case, which urged the court to affirm the right of corporations to spend money on political campaigns. Is he correct?
Yeah, there's a little Wall Street Journalish tone to that, but yes, he's correct. I represented on a pro bono basis Senator Mitch McConnell in the Citizens United case, and was one of the 2 lawyers who argued orally in that case for what we thought was, and I think.
By the way, which was Ted Olson, right?
Ted Olson.
Okay, who was at Chautauqua for those?
Yeah. Ted represented Citizens United, and I represented Senator McConnell. In fact, I'll divert and just tell a nice McConnell story and then get back to the merits. The Supreme Court has rules basically saying it is disfavored to have divided oral argument. You get half an hour total oral argument. They don't want a bunch of lawyers arguing. They want one lawyer from each side. But sometimes they deviate from that. Senator McCain was the draftsperson of the McCain-Feingold law, which limited spending by corporations as well as certain other things at issue in the case. And his lawyer had asked to appear, and the court had granted it. And so I was talking to Senator McConnell. He said, well, why don't you argue? I said, well, the court has a rule against it. And he said, I may not be a good lawyer. One thing I know is that if they're going to let Senator McCain's lawyer argue, they'll let you argue. And they did. From my perspective, this was a case, just think back to it. Conservative group, partially funded, not even very much, but partially funded by a corporation, did a documentary, an hour-long documentary, blasting Hillary Clinton. This was at a time when she was in primaries against then-Senator Obama in 2008, in which she was viewed as the likely Democratic candidate for president. The whole hour is why she shouldn't be president. This person saying one bad thing, that person saying another bad thing, etc. Under the law, that program could not be shown on television, cable, or satellite within 60 days of an election or 30 days of a primary because it was partially funded by a corporation. I thought and think that that violated the First Amendment, and that the notion of limiting political speech, let alone speech about who ought to be president, was the most egregious sort of violation of the First Amendment. Usually we say political speech and electoral, who to vote for speech, is the centerpiece of the First Amendment. Lots of other speech is protected, but that's what it's most about. And my view was that some rich person or corporation wants to spend money taking out ads. This is mostly about television ads, which is where the money goes. Wants to spend money by expending it on television ads, supporting or opposing candidates, that should be protected by the First Amendment. The court had earlier decided that individuals, not companies, individuals could spend as much as they wanted. They couldn't make direct contributions to candidates in large amounts, but they could spend as much as they wanted to buying ads or whatever. Citizens United was about that applied to corporations as well, and the court said that it did. I have recently done really a great deal of research to see how that decision really played out on the ground, and I have an op-ed piece coming out within the next week in the Wall Street Journal setting forth basically the proposition that when you look, because there is data, when you look at the last two presidential elections and the last four congressional elections, all after Citizens United, that you find corporations have been involved to a very small amount. That, in particular, when you look at 2005, 2006 data, which is just available, that these so-called super PACs, entities into which this money goes and then spend it, rather than people buying an ad themselves, that something over $1 billion was contributed by individuals to these super PACs. Something over $250 million was contributed by unions and other organizations, and about $80 million total was contributed for the 2-year period by all corporations. Now, I have a view as to why that is so, and I think it is so for a reason. Michael Jordan was often quoted as explaining why he didn't talk about politics. He does now, but why he didn't talk about social issues or politics. He said Republicans buy shoes too, and that he didn't want to offend half of the potential buyers of the products that he was advertising. And I think corporations have made a very smart policy decision. By the way, all these numbers are public numbers. The numbers I'm giving you don't happen to be well known because the 2016 numbers are just coming out. But this is all public stuff. And the court in Citizens United affirmed the constitutionality of that being public and the like, and that donors have to know that their names are going to come out. I look at these numbers and I look at the top 30 contributors over that 2-year period. One corporation, a Star Company, a sort of offshoot of AIG, gave $15 million. All the other 29 of the 30 are either individuals, topped by a person, an environmentally very engaged individual who gave $87 million to campaigns, via super PACs. But the only company was this company, which is not a large company at all. So I don't think it is true. I think I know that it is not true that the greatest fear of critics of Citizens United has come into being, and that is to say the understandable concern that corporations would be running America, that they'd pour their money in. One of the briefs submitted to the Supreme Court said, just look at ExxonMobil. They have so many $1 trillion worth. If they spent only blank $1 billion, they could control 65 seats in Congress by how much money they expended. ExxonMobil gave zero. Most big companies give zero. They spend money on lobbyists and other things, but they don't spend money on trying to fund advertisements or the like supporting candidates for public office. And then even, the story is although tinged with a little more pathos than I think is deserved, that it is true that liberal friends of mine, people with whom I tend to agree with on politics and policy, were upset that I was on the Citizens United side of this. One more thought that you might find interesting. I think that, oh, by the way, this opinion has brought the public together. It is one of the few things in American life on which the American public, on a nonpartisan, across party lines, agree with, which is they don't like the Citizens United opinion. Polling data consistently has shown 80% of Democrats and 80% of Republicans opposing what they understand the decision to have done. But I think the First Amendment argument is not only strong, but by my lights, compelling, and that's why I did it.
You're also representing Governor Andrew Cuomo these days.
I am, in a case, there is an element in Citizens United in which the vote was 8-1, and that was sustaining the provisions of public disclosure, that if you give over a certain amount, you have to disclose it, that it's public. That's why we have these numbers that I referred to earlier. New York State has passed a law just a few years ago saying that monies over a certain amount that go to charitable entities, 501c3s, 501c4s, over a certain amount, and if used basically what I'll call on political or social issues, have to be disclosed by the organizations that receive them. Certain organizations objected to that, and the ACLU has objected to that, basically on grounds of anonymity, that people shouldn't have to reveal, people, or I guess corporations as well, shouldn't have to reveal that information when they give to what are essentially, quote, good government, unquote, organizations. I think the statute is a good idea. I think particularly in light of Citizens United, particularly in light of the fact that so much money can be donated for political purposes, it's all the more important for the public to have information about whose money it is. And I think that's also true of these organizations. So I have been representing the governor on that. He has been dismissed from the case now, but the case does go on, and it'll be interesting.
As you look in your crystal ball and you see what has gone on with the massive leaks of Julian Assange, Edward Snowden. Where does that play in your orbit?
My book is very critical of WikiLeaks and modestly critical of Edward Snowden. I think WikiLeaks behaves in an irresponsible and sometimes deeply troubling way when it releases after the hacking of Sony, it released all the records, which means all the Social Security numbers of all the people who work at Sony who happened to be contained on the documents that were leaked from Sony. I think that's inexcusable on privacy grounds. I think on national security grounds, there are things that WikiLeaks has published which are troubling, and now there are very serious issues about WikiLeaks acting as an arm of Russia in the last political campaign, something I'm sure we'll be hearing and reading more about. Snowden is something else. I think Snowden served the country by revealing, at great risk to himself, information about the level of domestic surveillance that the NSA was engaged in our country. But I do think that Snowden's revelation of information about American intelligence gathering abroad is worthy of condemnation rather than support. So Snowden makes available a document, a journalist publishes it, an internal CIA document describing how the US and Norway and Sweden have a secret treaty to gather information about Russia. US planes or the US gathers information in some ways, the Scandinavian countries gather it in other ways, and we share it. Military information, political information, and the like. No one's going to die from the publication of that, and it was published in a newspaper in Norway when it was released by Snowden. But I think it doesn't show any wrongdoing. This is just what governments ought to do to protect their people. And so I think it's irresponsible and dangerous to leak that information, which was at a very, very high level of classified stature. Similarly, that you've surely read about, how we listen to the telephone calls. Chancellor Merkel of the president of Brazil. Maybe they suspected it, and maybe they do it to us. It just seems to me that someone who works for an entity who is given classified access ought not to reveal it other than for some very compelling reason, which, as I said, I think it was met with respect to the amount of domestic surveillance, but I don't think is close to being met with respect to these sorts of revelations of intelligence gathering by the U.S. abroad.
Professor Barbas, up there, graduated with a PhD in American history from the University of California at Berkeley. Berkeley's been in the news because of attempted various university speakers, which either got canceled and stuff. Do you have a comment on that? Is that the next frontier?
Well, it is a major area of concern, I think, and it should be. It happens to be right-wing speakers, often more than right-wing, pro-Nazi even in Charlottesville, speakers the First Amendment protects that speech. And I think on college campuses, sort of the wrong message has too often carried the day, the message being if a speaker has views which are really appalling to you or outrageous to you or even wounding to you, that the way to deal with it is to try to shut it down. That should not be the lesson that our students teach or the behavior that they should engage in. That is what happened at Berkeley. It's happened elsewhere. I mean, we've had a number of situations where speakers have been asked to speak. Condoleezza Rice, who had to cancel because of threats, and in other cases, people shouted down. I mean, the Israeli mayor of Jerusalem shouted down at San Francisco State. There's a lawsuit now pending about that. There's polling data on that, which seems to indicate that this generation is both, I would say, more kindly oriented towards its members and less concerned with free speech rights than earlier ones had been. The polling data indicates when you ask people entering college now, do you think people ought to be allowed to come on campus and say things which make other students feel bad? That almost half of them say they should not be allowed. And that's just not a First Amendment sensitive reaction. It is a sensitive reaction in the sense that it reflects, for the most part, concern about making people feel unwanted or aggrieved or the like. But it has seemed to me for some time as if we really need to go back to it in this respect, to go back to a time when civics was being taught in junior high schools around the country, and in which people were being given some background before they get to college about the nature of our political system and the nature of the Bill of Rights and the nature of what we protect and why we protect it. And I think what we've seen on more than one campus is reflective of that lack of teaching and lack of learning about some of these very basic principles.
Was that one of the premises for doing the book?
Yeah, yes, it was. Another one was that I had published an earlier book, and the deal was I would also do this book. but that's mere reality. I was saying earlier that before we came out, that one of the things I think lawyers are good at, I mean, there's all sorts of stuff lawyers can be mocked about. One of the things we're good at, we're really good about deadlines, you know. I signed an agreement with a publisher, and I think back to my first book, was 2005. They'd picked a date. It happened to be the day after Labor Day. And I sent in my manuscript. I got a call saying, well, no one's here this week. And our authors never really turn over manuscripts when they're due. And, you know, those of us who live in and out of courts, whatever else we do well or badly, if we have a deadline, we do it. In any event, yes, one of the reasons I did write this was I thought it, you know, on a long-range basis for anyone that reads it, that it might help to get a sense of why we have a Bill of Rights, and also, by the way, how close we came not to having it. to me, one of the more interesting things that I learned, no discovery, I mean, historians have known it, but how perilously close we came to having no Bill of Rights. I mean, you know, think of it. The framers meet in Philadelphia in 1787. We got 13 states. We have 13 militia. The English have lost the war. It's a free country from England, but there's no national government, none. And so they meet to move away from an association of states into a singular United States of America, not plural. And they draft this Constitution dealing with all these topics of the presidency, the judiciary, et cetera. And the subject arises. A member in Philadelphia proposes that there be a Bill of Rights. I mean, it's not that no one knew about Bills of Rights, and Jefferson in particular in France was continually writing about the need for a Bill of Rights of every free country and what all free people were entitled to. And the states voted 10-0 against having a Bill of Rights. The other 3 states had not arrived yet. So it was 10-0 against it. And then a delegate proposed, well, why don't we at least say the right of the press to be free shall be inviolable. Let's put that in the Constitution. And that failed by a vote of 7-4. Another state had showed up. 7-4. Now, why did it fail? It's not because they didn't care about free speech or free press. It failed because the prevailing wisdom then, as expressed by Alexander Hamilton, who was against having a Bill of Rights, was a sort of combination of, A, it's not needed. Why do we have to say the government can't do this and that? We never said they could do it. 2, or B, it'll be misleading because it'll sound as if these are the only rights. Whatever we list, we're going to leave stuff out, and the message will be what we left out is not protected. And C, lawyers are going to get up sometime and say, look, that's not there, that's not there. And it was all on purpose because they sat down and made a list of things that the Congress can't do. And the answer was, again, Jefferson's answer, a sort of, you know, don't tell me about that stuff. Everyone is entitled to a Bill of Rights. You shouldn't have a new constitution of a new country that doesn't say in so many words, and Jefferson said, and not by inference, that the government can't deprive you of freedom of speech, freedom of press, freedom of religion, which came first, actually, of the 3 in the First Amendment, or get involved. And during the ratification process, a number of states refused to ratify unless there was a Bill of Rights. And so agreement was reached finally that there would be. There's a lot of talk about whether it went into the Constitution or was amendments to it. So they finally did it. And it had seemed to me, and the point I try to make in the book, if it weren't written down, if it weren't said in so many words, and if it weren't law, not Jefferson's poetry in the Declaration of Independence, but if it weren't law, we would live in a very different and less attractive country. That it is because by chance or provincial design that they drafted a Bill of Rights and ratified it, and that judges have been its enforcer through the years, sometimes inconsistently to be sure, but nonetheless, the enforcers of it, that we've come to where we are, which in these terms at least, in terms of protecting individual freedoms, is very high and very protective in historical terms vis-a-vis the world and vis-a-vis our own history, and that we should be very grateful for that.
What's the question that you expected to receive today that you haven't?
At what risk are we by this administration?
Great question. Anybody else have that same one? Okay. You want to respond to that question?
Let me respond first by saying what we're not at risk of. Notwithstanding that the president has said a variety of things, such as we ought to change the libel laws and journalists shouldn't be allowed to use confidential sources, and to then FBI Director Comey, you ought to put journalists in jail for publishing things like that. Those things, I believe, are not going to happen. The libel one, in particular, is preposterous. It's not just not going to happen. There is no federal libel law. So we have 50 state libel laws, and we have a First Amendment which oversees or limits all of them. So the notion that the president said that we should change the libel law, there's nothing for Congress to do because there is no libel law to change that Congress has any jurisdiction over. So that stuff doesn't bother me except that he said it. What does worry me are really two things. One is that the Espionage Act, which was passed 100 years ago this year, during World War I, is very broad. And I could see a prosecution, maybe of Assange, for whom I have little use, but if he were charged under the Espionage Act and lost, as he well might, we'd have new and bad law which would impact the entirety of the American press, however responsible and loyal, patriotic the press is. That's one thing that concerns me. The other thing that concerns me a lot is the sort of daily denigration of the press by the president. The constant repetition of the notion of fake news, even when it's true, does send a message which a significant minority, but nonetheless a significant amount of Americans has accepted, which is that the newspapers are simply not to be believed, and broadcasters not to be believed when they say things critical of the president. And that seems to me really a dangerous new model. We've had lots of presidents who've been angry at the press, including Jefferson, who I mentioned a few times, lots of them. Jefferson once said, by the way, in a letter, newspapers ought to be divided into 4 parts: probabilities, possibilities, and 3 parts: probabilities, possibilities, and lies. And he said the last one would be the biggest part of what newspapers would have. But it seems to me that the sort of direct attacks on the legitimacy of the American press is very disturbing, and I think does have impact. And one of the impacts is that we're moving towards a time when there are no such things as facts, as accepted truths, that everything is up for grabs, everything can just be dismissed by saying, you know, he's on the other side, or he doesn't like me, or he's irresponsible, or the like. And while, as I said, and it, you know, throughout American history, I mean, it was Teddy Roosevelt who encouraged his Department of Justice to bring an action against Joseph Pulitzer to try to get him in jail. It was John Adams who got the Sedition Act, 1798, through Congress. I mean, we've had presidents, including some great men, who were prepared to do really bad things from a civil liberties, individual rights point of view vis-a-vis the press. But we never had quite a situation in which there was a constant repetition of the falsehood that virtually anything that is said, which is critical of the president, is, quote, fake, unquote. And I just read an interview with the president, I think 2 days ago, in which he said he thought one of the biggest, most important things he'd done is to use the word fake. And I'm afraid it is.
Wow. Anybody feel like they like you get double credit for con law today? This is incredible. The First Amendment Center said, ask someone to name a First Amendment lawyer. If they answer 100% of the time, they will be the same, Floyd Abrams. Then ask them to name another such lawyer. The answer, silence. It is a sign of the times that the name Floyd Abrams is synonymous with First Amendment in a way that virtually no other name is. Senator Patrick Moynihan once said, Floyd Abrams is the most significant First Amendment lawyer of our age. Ladies and gentlemen, Floyd Abrams.
Thank you.
Thank you. Thank you so much. Fantastic. Hard to figure out what the next step is. Ladies and gentlemen, Mr. Abrams will be here if you have any questions, and at the same time, there is some books, a few of them, that he has autographed. If you're interested, I think they're $25 a piece. Feel free to pick those up. At the same time, I invite everybody to join us for lunch downstairs. Also, make sure you complete and fill out the CLE form. See Mary Keating, as that is a critical part of today. And next step is downstairs, and we'll have a chance to interview Pat Coletta from the Buffalo Sabres. Thank you, everybody, and thank you, Floyd Abrams.